FM.
Need to get your goods to St. Kitts and Nevis? Look no further. TDC Shipping has you covered with reliable cargo solutions by land, air, and sea. Whether it's a package from across the world or a large shipment of goods, TDC Shipping makes it easy, affordable, and stress-free. And with our airbox service, ordering from your favorite online stores just got even easier. Ship straight to your mailbox and let TDC Shipping handle the rest. Fast, secure, and even to your door. Visit us today at the C.A. Paul Southwell Industrial Park or Penny's Industrial Site, or call 465-2511 in St. Kitts or 469-5430 in Nevis. TDC Shipping, where reliable service meets unbeatable convenience. TDC, together we succeed.
And we're back with you, and we'll be joining Mr. Chesley Hamilton momentarily. But let me, before I do that, we will be engaging you in conversation further along. So I'll give you the phone numbers that you can contact us on. The numbers are 466, that's the local numbers, 466-0989, 662-0989, 762-0989. In the UK, 033-344-0065. In the USA, 718-285-6984. In Canada, 305-921-4619. And we'll be looking forward to your engagement as we go along on this presentation of Inside the News. I now turn you over to Mr. Chesley Hamilton and say good day to you, Mr. Chesley Hamilton, and how are you today?
Good day, Quint. I'm well. Good to be back in the winnfm studios. Inside the News is a program that I am fortunate to be part of the initial time when the broadcast began with Mr. Clive Bacchus
Yes.
and others. Those days, the hot topics used to be Nevis and the Federation and secession. And then we had another round with boundaries and constitutional reform. And then I remember sometimes we used to have Raskolunji here, and we used to be dealing with a strange phrase, cannabis sativa, which is now known to everybody, marijuana and the whole process. Those days we were discussing things that people thought we were out in left field, and today I'm happy to say that the State of the Federation and Section 113 of the Constitution is no longer the burning issue. We have other issues on tap, and today issues of marijuana and plea bargaining and single judge trials, which means trials in the High Court without with the judge alone. Those are more of the burning issues, but not getting perhaps the consultation and the level of discussion that the people would like, and that's one of those things that is different. So I'm asked to come in for Inside the News. Then we used to go from 10 to 12 or 12:30, and then we come back in the afternoon for another hour. Now it's 2 hours, and I'm happy to be here to share. They said sometimes when you're into political and policy making, you have to both educate and entertain at the same time. So I'm happy to be here. Quint, what's in the news?
Well, you bounced on two things that I would like you to perhaps delve into, and that's, I'm sure that you're quite well afraid with them. For instance, one, how do you feel about the judge alone thing? And also, perhaps we can touch the cannabis story because there has been some, of recent time, there has been some Rastas who are not too comfortable with the prices that they heard bandied about that they would need for licensing and so on and so forth. So I don't know which one you would want to pick up first, but I leave it to you because you're well au fait and articulate on many aspects. So I'll leave it to you and then I'll follow your lead.
Okay. First, I want to also say congratulations to the government of Trinidad and Tobago. Ms. Kamala Prasad Bissessa has been returned. I had a conversation one time with Michael Manley in Canada, and Michael said to me that it is indeed a privilege to serve your country at the highest level twice.
Yes, most definitely.
He said, don't take it for granted. Not too many people get the opportunity to serve at the highest level a second time.
Yes.
And Kamala Prasad Bissessa, that privilege and that honor has been bestowed upon her by the people of Trinidad and Tobago. So the voice of the people is the voice of God. So therefore,
Do you believe
people
that
have
phrase?
spoken.
Do you believe that? I don't believe that phrase.
They say. I didn't say I say.
Okay.
Okay.
I think that's one. I think that's one of the phrases they bandy about to give themselves credence and credibility after they have been elected. No matter what means they use to get elected, they say the voice of the people is the voice of God. Yes.
Well, when you say the over, there's a phrase that says God's willing. So therefore, if it's the will of God,
Yes.
then I'm quite I'm more
Happy
amenable
with it. Yes.
to that phrase. If it's the will of God, God's willing.
Yes.
Somebody say, "I'll be here tomorrow." God's willing.
Yes. Yes.
Yes. By the grace of God. There
Yes,
go.
yes.
That's a phrase I use more often.
Myself.
I
too.
tend to tell people that the difference between myself and my clients are those 6 words.
Yes.
But for the grace of God.
Yeah. Well, I say, but for the grace of the Almighty.
Yeah, wonderful. So I just want to say congratulations to Kamala Prasad Bissessa and her team. They got
Good
almost a
mandate.
super majority, a good
Yeah.
mandate to
Yeah.
lead the people of Trinidad and Tobago for the next 5 years. The coalition of interests and the UNC. So I want to say congratulations. I will even go a little further back and congratulate Ms. Cora Richardson in Anguilla for coming to office as well. So now Mia Motley can, when she has regional meetings, can say brothers and sisters.
Yes. Just recently she complained about that.
Yes, she said she wished she could say brothers and sisters,
Yes.
but she could only say brothers. Well, I now know that maybe with Cora and Kamala,
Yes.
she can now say brothers and sisters and be a little bit more comfortable in the room.
Yes.
That there is a balancing out of the gender
Yes.
within the rooms and the discussion. So yes, congratulations is due. I happened to be in Trinidad last October in the Prime Minister's constituency, and she held an event for Duali, and I was I was the one who was asked to introduce her in her constituency to the population, and I was happy to tell the people of her constituency in Trinidad and Tobago that if Bazdia Pandey was their Moses and Kamala Prasad Bissessa is the Joshua that will lead them to the promised land, having prophesied and see it come to fruition,
Yes.
I am happy and happy indeed. So congratulations there. I just wanted to put that out there. And I'll go into one of the topics that you asked me to touch on.
Yeah.
Let's deal with the
Judge.
The judge only?
Yeah, yeah. You choose if you.
Now, there have been some developments in the criminal jurisprudence going over the last 2 years or so,
Yes,
many of which I'm not very happy about. And, you know, I practice predominantly
Yes.
criminal law. I believe that one has a right to a trial with a jury
yes,
of their peers.
yes,
There are only two times that the population, the people, have a great voice in an active voice in a democracy.
yes,
That is on election day, when everybody's supposed to have one man, one vote, or one woman, one vote, one person, one vote. And therefore, even the Prime Minister and you have the same right, that one person, one vote on election day. And that may come by every 5 years. For instance, in Nevis, because of the local elections, you may get that opportunity probably twice within a 5-year period. But the second one is jury participation.
yes,
One of the things about jury participation, which a lot of people don't know, and the development of jury participation, is that before around 1927 or so, only white men could be on the jury.
yes,
In fact, there's a act which called the Persons Act, which gave women the right to vote after World War I.
yes,
And I think there was someone on the throne in the British Empire that says, if you think a woman is not a person, then come forward. And, you know, Queen Victoria, I think, was able to sign that law into being, where giving women personhood.
yes,
And that right came about because what happened in World War I, that a lot of men went off to war, were killed, they left property, and their wives wanted the right to that property. And sometimes, because women were not quote-unquote persons,
yes,
they couldn't own that property because they are property themselves,
Yes.
the property of men. So they had to change that in order for women to be given the right to not only own property, but the right to vote.
yes,
At around 1952, and again, after World War II, wars changed things.
yes, definitely.
You know, after World War II, once you had property, not just the wives of soldiers, but everybody, universal suffrage came in. But that universality came to say, well, you had to have property, a person in good standing and property to vote.
Yes,
And to then, if you were on the voters list, to be a part of not only voting, but to be become a jury, because the voters list is what helped you to be selected
yeah.
to
be
become a juror.
Yeah,
So it's only during the struggle you know, the against imperialism and colonialism and liberation of the people, you know, the fight with the trade unions, you know, the fights that, you know, people like Bratcher and Byrd and these guys fought for the people to have universal suffrage, to have the right to vote, irrespective of their economic standing.
yes, yes,
And the fact that they didn't own property and so on. They were then given the right to vote, and a derivative of that Deriving out of that right to vote was the right to sit on a jury
Yes.
without having to say, well, I got property or not.
Yes.
Because it's not only people who have property could decide what is justice and what isn't justice. So the right to be tried by a jury of your peers is a universal right now, and a right which was fought for. For the government to come and decide that it's not giving you an election, it is making it mandatory that in some cases you don't have that choice.
Yes.
You're going to be tried by one man and one man only.
Yeah, and where I'm concerned is the mandatory in some cases. Who picks the cases? Who determines?
There is a whole list of acts, and I'm sorry that I didn't walk with that bill, because there's a whole list of them that are listed in a schedule that those are made mandatory, and it is it is not for the accused to choose whether, I don't believe I could get a fair trial by a jury because I am Quint and I'm very popular on radio, and a lot of people don't like me out there in radio land, so I don't think I'm going to get a fair trial. So in order for me to get a fair trial on this legalistic matter, I am going to choose to be tried by a judge alone.
Yes.
Because it's a legal argument and I want a judge to try me.
Yes.
Because I don't believe the population is on me with this one. Let's say that Quint defense was, he suffered from sleepwalking.
Yes.
And he got up, drove his car from Connery to someplace, St. Paul's, commit an heinous crime. He said, well, how could a man drive that far?
Well,
How could a man drive that far while sleeping?
And I would have to be sleeping,
You understand?
sleepwalking, because I can't drive.
That's my point. That's the point. You understand? And that was his defense, that this man was actually sleeping and that is his defense. The population will say, "Boy, you gotta be crazy." But it's a legal defense.
Yes.
And you bring in the medical people and so on to say that this is capable and possible, and it is one of these things that science has shown that people who sleepwalking are capable of doing all manner of and so forth. You could have something like that. So you may choose. It's an election.
Yes.
That's not the case in this law. The law gives some mandatory things that says these must be tried by judge alone.
Yeah.
And I have a problem with that.
I have a problem with it.
The second thing is, the second part of it is that if a case was tried by a jury,
yes,
and for some reason the case was aborted, misconduct, I may have the jury, somebody inadmissible evidence went before the jury, and the judge decided to abort that trial. That trial must go back to be retried, but not retried by a jury. Retried by judge alone. I have a problem with that.
I have a problem with that.
I have a problem that if a judge make a mistake, then rather than you having an opportunity to deal with that at the Court of Appeal, the judge get a second crack at it to fix his or her mistake.
Yes.
That can't be due process.
No.
So therefore, I have a problem with that. The other aspect of this law is, if they do something, let's say it is a shooting or a major crime, and when you talk to the jury said you ask the jury certain questions and they say they are in fear. If the jury is in fear, that's a ground to have a judge-only trial.
Yes.
And I am simply saying, but the easiest thing for a juror to say is I'm in fear.
Yes.
Without more. Because they could easily say, I don't want to be in a jury duty. Okay? I don't want to do no jury duty. I want to go work. I am a single businessman. I am going to be away from my business, making no money, but I ain't fear.
Yeah.
I fear to do this trial.
Yes.
This is shooting, this is gang related or something like that, and I got to go live in that neighborhood. I am in fear. Bam. That's a ground for it to be tried. Judge only. Quint, we have been through spikes in crime. when the gang war was in and we were conducted trials. There was no issue of jury interference. We don't have no overwhelming issue of jury interference, jury intimidation. None of that is part of our jurisdiction.
Yes. So
We have had free and fair trials in this country. All of a sudden, you bring this legislation and put it there, and to take away the rights of people, because what I tell people, the people who go to trial are innocent until proven otherwise.
Yes.
So it's innocent people like me and you and others who have to face the criminal justice.
I particularly like the latter point you made. Where is the problem with the jury system?
There's no problem with the jury system.
For you to come
with this draconian law to decide to take away all of these things and say, judge only. One man or one woman to decide your faith.
Yes.
But it is not just that, Kim. Once ago, you had something called a preliminary inquiry.
Yes.
Where you get a chance to test the Crown's evidence, to get it all there. And once that becomes the deposition, that is the evidence that comes part of the deposition, which goes to trial.
Yes.
The Crown, only under certain specific circumstances, could depart from that. And when I say depart from what's there, if there's some fresh evidence that come, they have to make an application for fresh evidence, to adduce fresh evidence and so on. And they will make that application. If someone died, they may want the evidence reading. So you had a preliminary inquiry, and at the preliminary inquiry, you had an opportunity, the accused, to cross-examine, to test the evidence and so on. That is no longer part of the process,
Wow.
You now have something called a paper committal, where they prepare some papers,
Yes.
some statements, out of court, right? Not before any magistrate, not before anybody.
And without
any cross-examining, right?
Yes.
You take those statements, put them in a bundle, called the paper committal bundle, and send them straight with the magistrate, straight to the judge to be tried. That is, in my opinion, my humble opinion, not due process. But that is part of the process now. You have abandoned preliminary inquiry. You now go on to paper committal. And people may say, well, other places have it. Other places have paper committal. So what is your issue, Chesley? In Anguilla, paper committal is an election by the accused.
Okay. So the accused, who you want to put on trial, has a choice.
To say, listen to me. This is a case where you say, I committed fraud. I forged a lot of documents and so on. I don't believe that the jury going to follow this. I believe you need a person who understands white-collar crime.
Yes.
To try me. I am going to go for paper committal. Because this thing is paper-driven. Okay? It is an election in Anguilla to go paper committal. But that's not the only thing. The election is not the only thing. In Anguilla, the out-of-court statements comes as evidence in chief, meaning this is, on the face of it, the evidence against the person. But the person has to come in court before the magistrate, where the statement is read back to them, and the magistrate will say, is that your statement?
Okay.
And they said, yes.
Yes.
Good. So it's an oath.
Yes.
They sign their statement, and it becomes part of the committal bundle.
Yes. Because the accused had a part in
and now the accused also could cross-examine them if they choose to.
Yes.
This is important. Why is it important? Let's say the person goes away and you want to use that evidence. Well, the accused had an opportunity to cross-examine. They didn't take advantage of that.
Yes.
Suppose the person died. You could read that in. Okay? Another step to that. The magistrate then have them sign the statement, and the magistrate binds them over. It's called bound over. To come to trial to give evidence in the High Court. So you have now a duty to show up.
Yes.
Right? Now, if you don't show up, they can issue a warrant for you. But just imagine The process that we have now, Quint, you give the police a statement because you are a good citizen who say, boy, listen to me. I see certain things and I'm going to help. You know, because I'm a good community-minded person. I give the police a statement. They take a statement from you. Quint, you're going about your business. They put that statement in at part of the committal bundle. Right? In the paper committal. When time for the trial now, you don't plan their holiday with your family or whatever. You decide, but no, I can't come.
This, yeah.
You know what they do? They issue in a warrant for your arrest, Quint.
Wow.
Nobody bound you over. No judge, no magistrate says, Quint, you are to show up to court. So you're not violating no court order.
And the individual who is supposed to be a witness against you is not able to come and be a part of the process.
And they are issuing a warrant for that person.
Wow.
So why should I assist? If that is the fate I'm going to find myself in.
Yes.
I tell you, there's some serious problems with this legislation.
But when I listen to you, this sounds more like we're going back to colonialism.
Boy, I move to the front of the class, Quint. Move to the front of the class, Quint, because if I say, they're going to say I am attacking individuals.
No, but I'm a student of history, so
Quint, if I, Chesley O'Neill Hamilton, say, they're going to say I am going back. I am attacking individuals. But this goes back to the days when the governor appointed the cabinet, when the governor appointed magistrates, when the governor appointed the cabinet, when the governor appointed everything. And now you have one person appointed, not elected, nothing. One person deciding whether you can go to jail for some serious time. Double digits.
Yes.
That cannot be right in a democracy.
Cannot be right in a democracy.
And this is where we are going. I am saying we are going backwards. But it's passed off as reform. Reform. The criminals are this and the criminals are that. Right? Quint, there is, we came out through a period during the unity government where serious crimes were down, murders and so on were down. Coming out of that, you can't begin to say that crime is out of control. You cannot say that. So therefore, what is the need?
What is the criterion for you?
For you to decide that, listen to me, this is what we need to do to stamp down on the rampant criminal spate or whatever we have. What is the need? What is the drive for it? Self-aggrandizement? Quint, right now, because of this process, okay, we have almost 100 cases waiting for trial in the High Court. Almost. Upwards of 50 cases. I want to say upwards of 60 cases. At one time it was close to 80. I don't know if some have been dispensed with. Never in our history was there an assize where there were 40 cases. Never. All of a sudden now, we are up there. And you know what they say they're going to do to solve the problem? They bring in an extra judge. Now, listen, crime isn't rising, but we need an extra judge because there's a bottleneck. We used to have one judge dealing with civil and criminal. One judge. We have gone to trials all year round. We no longer just have the January assizes, the April assizes, the May assizes, the September assizes. In fact, at one time you had the January assizes in St. Kitts. You had and that will last from January to February. You had the March assizes in Anguilla. You had the April assizes in Nevis. Then you had the May assizes in St. Kitts again. And then you sort of break at the end of the year. Then you came in September. Again, you had in September the St. Kitts assizes. And in October, you might have Anguilla, if there is anything to do in Anguilla. And in November, again, you go back to Nevis. That's what you used to have. So at least if you're practicing criminal law, you know where you're going to be as the asylum. Now you're going to year-round trials. So anytime the judge could call you, anytime, you can't plan. You can't plan a vacation, you can't plan a holidays because the judge could call you at any time now. You're going to year-round trials. Okay? So you can't limit your practice because you want to limit your your practice. Okay? So you're going to year-round trials.
So you can't as an individual get any leisure time.
Well, I don't even want to call it leisure time because it sometimes you need to do things in your office. You need to do things else in other aspects of your professional life.
Okay.
There's time to travel for professional development. There's time to travel to do other things. All right? But when the court say come, you have to then go because, hey, I tell people, judges and magistrates are the only two people I don't knock glass with because they're the only two people who could take away my liberty.
And this is, I'm glad you said that because this is where a defense and defense lawyers come in. Because here's the judge, the magistrate, and also the prosecution. And we know the prosecution usually follows the state. So without defense and defense lawyers, the individual charged with a crime has no real legal recourse.
And this is why I these are laws that are passed, Quinn, without much consultation. Because somebody regionally might decide, well, this is one of the things that we want to do. The fact that something work in Jamaica or might work in Trinidad doesn't say it is the best thing for St. Kitts. And sometimes that is the way we go because we have this thing where we believe that once they do it, we should do it.
Yeah, follow fashion system.
You know, it is not always that way. I have seen heads of state come here, see things in St. Kitts, take them back to bigger places and adopt them.
Yeah.
You understand? I have seen we have something here started by a young man from Connery called Ainan. It is something he started over Freeway called a strip.
Yeah.
Almost everywhere I go now have a strip.
First cousin of mine.
Okay? You go to Anguilla, they have a strip. You go to Montserrat, they have a strip. You go to Trinidad and Tobago, they have the Avenue, which was fashioned after the strip here. I am just simply saying to you, almost everywhere you go, but nobody is going to give you Ainan, the little skinny rasta who went to boys' school with me, the credit for
being so innovative.
The entrepreneur.
Yes.
That gave that sort of initiative to him.
And
Started with a cooler, then out of the back of a vehicle, then put up a little shack, and then all of a sudden everybody see, well, boy, this is something that we can continue to do.
And this is something that adds to our GDP.
We don't have a wonderful place called a strip, but people don't give credit to people that look like Ainan and you and so on. They want to give it to other people. So coming back to the whole issue.
Well, before you go there, let's take a bit of a commercial break.
Wonderful.
Give you a breather, and then we'll be right back.
We're different. We're 98.9. 98.9. Win FM.
Shopping with TDC just got much easier. Here's how. Log on to shoptdcgroup.com. Shop at your convenience at any time, from anywhere, with your smartphone, tablet, or computer. With our safe and secure payment checkout, you choose the option to pick up in-store or have your goods delivered right to your door. It's that easy. Shop tdcgroup.com, your one-stop online store.
Shop anywhere, shop anytime, same quality you love. Now online. Shop
www.shoptdcgroup.com.
Heritage matters to me. Heritage matters to you. Join me, Percival Hanley, this coming Friday and every other Friday at 10 a.m. to 12 noon for Heritage Matters. on Win Media SKN 98.9. Heritage matters to me. Heritage matters to you. Maybe it's the way the brilliant gold liquid reflects our sunshine, or how the bright blue of its label mirrors the clear Caribbean skies overhead. Maybe it's the fresh, crisp taste of this beastly cold beer on a scorching hot day. Maybe it's even the way it brings us all together. But one thing is for sure, Carib is very much a part of who we are wherever we're from in the Caribbean. Carib, it's the way we play. Drink responsibly.
The importance of co-parenting. Every child has the right to bond with the parents that gave them life. Children are happiest when they can freely communicate and enjoy the time, talents, and lessons that each parent brings to the relationship.
We make co-parenting difficult when we focus on differences rather than what is in the best interest of our children. Parents, your relationship with each other should never affect the relationship you have with your child. Celebrate your children together. They deserve your best. A message brought to you by the Department of Probation and Child Protection Services. Contact us at 467-1311 or 662-6833 for more information.
And we're back. The time is approximately 10:44. We're in the first half of today's edition of Inside the News. And when we get into the second half, we'll be opening up the lines and imploring you to take part and lend your voices to our discussion. But as it stands at the moment, we take it right back to Mr. Chesley Hamilton.
Yes, Quint. I'd like to get the engagement of the people out there, because in the second half, I would like to discuss the whole issue of another piece of new legislation, which the government just passed, which is the plea bargain legislation.
Okay.
Now, what a lot of people don't know is that plea bargaining was not a formal legal part of our
due process
jurisprudence.
Yeah.
You know, you heard that from time to time, people, lawyers getting into trouble for interfering with the course of justice and so on. And that is because the guidelines and the pathways to deal with some of this are not specifically articulated.
Yes.
And the procedure was not as clearly defined as it needed to be.
Yes.
And some people got into trouble for crossing some lines. I don't like plea bargaining. You might say, really, Chesley? In the United States, most cases, almost 98%, are settled with plea bargain. Yet they have a process for that.
And let me say, I think that is one of the reasons why their prisons are filled with
right.
People of our darker pigmentation.
Yes, and a lot of people assume that plea bargain means you're going to plead guilty.
Yeah.
A plea bargain could be you're going to drop the charges. That is my definition. Because in the legislation, there's an assumption that a plea bargain means you're going to plead guilty, and we will then negotiate what the sentencing or what something else may be.
Yes.
That is not my understanding of what a plea bargain is. I practiced in Canada, where part of the process was something called council pretrials, where the council meet, and special pretrials, where you may be asked to meet with the direction of the judge, tell you, go back and deal with this or that and so on. So I practice in that realm. You may go to the judge and say, Judge, we would like this matter to be diverted, which is to put into diversion, because Quinn was found with a little spliff. He's a first-time offender. There's no need to go to a trial, but if Clint take responsibility as a first-time offender, he couldn't be offered counseling and substance abuse treatment and so on, and do some community service with the counseling and with the with the treatment for the substance abuse, and he end up at the end of that process with no criminal record. It's called diversion.
Well, let me
Hold on. Let me just
okay.
finish the thought, and I'm coming.
Yeah.
So that is part of the formal process in Canada. So I have practiced in areas where there are ways where you can end up with a person ending up with no criminal record. It's not a matter of pleading guilty and ending up with a criminal record. You have taken responsibility, you're being diverted, and you don't end up with what is a guilty conviction. We are assuming that in this legislation, plea bargain means you're going to plead guilty, and then there is a sentence that may have. But here is the sting in the tail. If the judge does not accept the plea bargain, can refuse that, and you're asked to go back to square one, what may happen in the second time around is that the judge is asked to, if there's a trial, if the judge does not accept the plea bargain, that judge has to recuse him or herself from the trial. But before we come back in the second half, I'm going to have you look at section 65 of the Constitution, which deals with the powers of the DPP. And the powers of the DPP, it states that the DPP can start, continue, all right, or terminate any criminal matter. And the power vested in the DPP is to the exclusion. Listen to the word. The exclusion of every other person, any other person or authority. So where does, if any other person or authority is excluded, where and how does the defense counsel, the aggrieved party, or the judge gets in to the DPP's constitutional right to start, continue, or end any criminal matter? And to the exclusion, not be directed or anything like that. To the exclusion. That power is vested in him to the exclusion of any other person or authority. Somebody need to explain to me how I get in as a defense counsel, or how the judge gets in to that authority.
But Chesley, that is why I wanted to interject, because you gave us the Canada scenario.
Yeah.
But I'm going to use the United States scenario,
Okay.
where a lot of black people wind up in prison for misdemeanor. And they use the same plea bargain process. And for them, they use what you're referring to, what we want to do down here. What they do is, if you're Caucasian, the Canada part applies, where you get through and you can wind up with well, it's your first time, and you come out with a no record. But if you happen to be a black, it's a whole different scenario. It could be your first time, but you wind up in prison because someone along the way decided, well, when you made the plea bargain, you pleaded guilty. You see? So the plea bargain can work for you and against you depending on who. And then we saw the case we've seen many cases where the DPP or whoever the main, when we have that thing that you spoke about where preliminary.
Yeah, the preliminary inquiries. Yeah.
You have preliminary inquiry. And before it goes to anyone else, someone makes a decision and say, okay, you walk free. When we, looking from our perspective, see so many question marks and so on and so forth, but that individual determines that you walk free. So that is like giving the powers that the DPP now has to say, well, okay, irrespective and regardless of anyone else, I make this decision, and that decision goes.
Yes, certain discretion is vested there to the exclusion of anyone or any authority.
Yes.
And but it's how that discretion is is exercised. And one is the legislation is simply saying no, that a judge should oversee. That's kind of how that discretion is exercised. There's a process for that, It's called judicial review.
That's it.
You understand?
Yeah.
But you going to pass the legislation to put the judge in the arena.
And let me ask you, because you're the lawyer here. Isn't a judicial review more democratic?
Yes, because you then say a decision was made, don't care who is the public official who made the decision, and you want the court to review it.
Yes.
I mean, even if Parliament passed a bill, you could go for judicial review. You understand? Everybody is subject in a constitutional democracy.
Yes.
To the arbiter, which is the judiciary.
Yes.
And that is why you have 3 independent branches. Cabinet make decision. You say, listen to me, they have made that decision, but we think that the executive, they have violated this person's right. We want judicial review. We want a matter of fact, even if they make a no decision, a non-decision could be reviewed. You could demand that they make a decision. This is how the process works. But all of a sudden, you've taken it upon yourself and you go on and carve out something to, again, bring the bench into the arena when the bench has no call in the arena. The bench has no call in the arena. I'm going to give you a little history before you come in again. Yeah. I'm going to give you a little history. When there was the independence talks in St. Kitts and Nevis, and you need to know your history in order to honor and respect things. When we had independence, Limo and the Labour Party were very against, the PAM NRP in the first term deciding to go for independence. Because, hey, you just came to power in 1980, and by 1983, you don't table white paper, green paper, and you're gone to independence. You need to go face the polls before you go back, you talk about independence.
Yes.
But these guys were quick, they were doing things, and they went to independence. Limo said to them, if you want me to contribute in any meaningful way, give me this one thing. Give me the separation of the Attorney General from the DPP. Limo and Bryant had got arrested during the first term of the People's Action Movement and the government. And Limo was adamant that he wanted prosecution, because before then the Attorney General office, the Attorney General office did the criminal trials in the as it's done in Anguilla and to some extent in Tortola. Even the DPP's office in Tortola is part of the Attorney General's office.
Yeah.
The Attorney General does the prosecution. The Attorney General's office does the prosecution in Anguilla. So that was one office, one person, head those 2 departments, the criminal and the civil part. Limo asks for this independent DPP, separate and apart, and not be directed by an Attorney General. So we have an independent DPP, separate and apart from a lot of other jurisdictions. If you don't respect that and think that other people, Attorney General and the DPP, applies to St. Kitts and Nevis, you don't know our history. That was the one thing that Limo wanted, up and above anything else, in the St. Kitts and Nevis Constitution, and he got it. I'm not going to talk about the Brian Clause and I'm not going to talk about the Billy Clause.
Yes.
And a lot of people don't even know there's a a lot of people don't even know there's a Connor clause.
No,
Pastor Connor, Pastor Connor. We didn't want. They didn't want Pastor Connor to be an ordained minister and run for a seat in the village. So they put in the constitution that if you're an ordained minister you can't run for elected office.
Okay,
People don't know that clause.
I heard that, but I didn't know it was referred to as the Connor clause.
It was to keep Connor out.
And only recently, I learned about the Billy clause.
Ah, okay.
Yeah. So what I wanted to interject and seek your enlightenment on is a judge.
Mm-hmm.
As far as I know, as a layperson, the judge presides over the case, and after the prosecution and the defense put forward the case, and it goes to the jury, and a decision is made, the judge then gives a sentence. Am I right?
Basically, you are right in terms of the steps.
Okay. So
hold on. In a criminal trial, one of the things that you would hear judges say is that on the law, I am supreme.
Yes.
On the facts, you, the jury, you are supreme. Well, when you have a judge-only trial, you know what happened there?
That is why I asked you the question.
You know what's happening there? The judge is now supreme and the facts are on the law.
That is why I asked you the question, because, and notice how I asked the question to be enlightened. I asked the question, I'm going to rephrase, isn't the judge presiding over the case, the prosecution and the defense presents their sides, the jury makes a decision as to whether you're guilty or not, and then the judge now decides your sentencing.
Yes, based on the law.
Yeah.
And the issue is, there, the evidence, the jury hears the evidence, and the judge decides the law. What is admissible and what is not admissible, the judge is like the referee on the law.
Yes.
So the judge is they would say, supreme on the law, and they must take his legal guidance.
That's it. We have a caller.
And then the jury on the evidence is supreme on the facts.
Yes.
In the judge alone trial, one person is supreme on the facts and on the law, and then that one person turn around and clap the sentence underneath you.
Hello, caller.
Yeah, good morning. Good morning to you guys, man. Good morning to you guests.
Good morning.
You know, Quint, you know I'm about to put your guest right on the spot. You know, I heard him say that he you know, I'm going to say this, but maybe I'm going to retract it too, but he said he don't want to talk about the Brian clause. Yeah, that might be a whole different topic, a different time for a different discussion.
Yes.
But I certainly want to tell him that they got people out there like myself, you know, who wants to get that history and that Brian clause. You know, I'm a person that's advocating to remove that from the Constitution. And I'm gonna put it to him, if you could allow me, please, because I need to get that history. You know, I'm definitely gonna ask him, can he say something about it? You know, it doesn't have to take up that long, but I want to get that history behind that clause. You know, and also
stick a pin.
Stick
a pin.
Yeah, okay, go
one
ahead.
thing at a time.
Yeah, go ahead.
Stick a pin, one thing at a time.
Yes, go ahead.
I am going to get a lot of licks
ahead.
for this. I am going to get a lot of licks for this. Because, you know, Bryant was Labour, you understand? Permanent NRP, and they decided, but listen to me. Fitzroy wasn't born here, son. He, don't think any of his parents were Kittitian, and to some extent, that person shouldn't be allowed to run for elected office. So that's the Bryant clause. But I am against it. Why is Chesley against it? Why is Chesley against it? Hold on. Why is Chesley against it? We you that was born in Dominica.
Southwell, right?
That's my point. How could we have a national hero, a foreigner who contributed to this country at the highest level, right? As a national hero.
He married to my... Yeah, I know him pretty well.
You understand? And then you turn around and say, if you're born elsewhere, or if you have citizen elsewhere, you can't contribute at the highest level. Something is inconsistent about that. And therefore, I am simply saying, I don't like it. You know, the Billy clause is basically saying, if you run for political office, as I did on a number of occasions, and you lose, you are not supposed to be then appointed.
Chesley camera stick, so he's stuck in one position.
Yeah, you're not supposed to be appointed to cabinet where you will be given the public post, because the they're saying the population, the electorate has rejected you. In other countries, in Trinidad, in other places, you could be made a senator and then become a minister, and you'll have all sort of power and even end up with a pension. Should I say that I prefer that? I was for a long time saying I don't believe a person who loses at the poll should then be given that kind of power and authority. And sometimes, just imagine the guy Douglas in Sandy Point would be made a minister, and he will have way more power than Sean Richards, who the people elected to do all manner of things. Something seems a little unfair there. But when you look at it at another way, he has put himself forward once, put himself forward twice. And at the end of the day, he has given so much to his party and probably his community and country. And then what is going to happen? You're going to say that he shouldn't be able to contribute at the highest level, at the cabinet level, and perhaps go right off in the sunset at some point after 10, 15 years of contributing to with a pension or something. Something seems a little unfair somewhere there. You understand? So I'm simply saying we need to look at things a second time or through a different eye and see how we can change some of these things to better our democracy.
And that's exactly what needs to happen.
So that is my view. That is my view on the Billy clause and the Brian clause. But then I know somebody's going to come and say, well, why can't an ordained minister, because he's in the pulpit, why can't he then run for political office? And somebody's going to say, let me throw
out my stance, if I may. You know, a game of cricket, you have a wicketkeeper on your side, and I have a wicketkeeper on my side. If the politicians of the day, locally on the ground, are scared of persons in the diaspora to come back and challenge them and run, what I see with that is that just as well as one party can recruit a person from the diaspora, the other party can do the same. So the playing field will be level still. It always is going to be level. So I see that Brian clause as just a barrier around certain citizens.
Well, it's going to come to a head.
Because
it's going to come to a head soon, because, you know, and forgive me. You know, the Indians and the Chinese and the Spanish are getting their children here in St. Kitts, and we are going to the States and elsewhere to get our children. So sooner or later, when the Stuart Young of St. Kitts, you know, with some
recently,
you know,
I brought up that topic.
When the Stuart Young of St. Kitts is nominated for Prime Minister, somebody's going to cry out and say, "Hey, how come my son can't be Prime Minister? And have that person who came all the way from Southeast Asia is now Prime Minister."
The whole thing about his friend.
Hold on, caller, hold on. Don't hang up. We have to make some changes to the camera here. So we're going to take a bit of a commercial break. Stay on the line, and we'll be back. Okay?
Yeah, thanks.
Found the Sound 98.9.
Okay, go ahead.
It's the start of the week. It's time for a new perspective. It's time for Unfiltered. Join Azar Gums, lawyer and deputy leader of the People's Action Movement, for raw and unfiltered political analysis of the current events in St. Kitts and Nevis. Tune in every Sunday evening from 7:30 p.m. on WinFM. Join Azar Gums as he breaks the mantle and cuts through the unfiltered political noise to bring you the facts. Unfiltered every Sunday evening on WinFM 98.9.
Need to get your goods to St. Kitts and Nevis? Look no further. TDC Shipping has you covered with reliable cargo solutions by land, air, and sea. Whether it's a package from across the world or a large shipment of goods, TDC Shipping makes it easy, affordable, and stress-free. And with our Airbox service, ordering from your favorite online stores just got even easier. Ship straight to your mailbox and let TDC Shipping handle the rest. Fast, fast, secure, and even to your door. Visit us today at the C.A. Paul Southwell Industrial Park or Penny's Industrial Site, or call 465-2511 in St. Kitts or 469-5430 in Nevis. TDC Shipping, where reliable service meets unbeatable convenience. TDC, together we succeed.
Maybe it's the way the brilliant gold liquid reflects our sunshine, or how the bright blue of its label mirrors the clear Caribbean skies overhead. Maybe it's the fresh, crisp taste of this beastly cold beer on a scorching hot day. Maybe it's even the way it brings us all together. But one thing is for sure, Carib is very much a part of who we are wherever we're from in the Caribbean. Carib, it's the way we play. Drink responsibly.
People make the world go
And we're back with you. Had to make a bit of a break there to deal with some technical problems, but we are back on track. The time is approximately 9 minutes after the 11 o'clock hour. You're listening to Inside the News today, and we also have a caller who is interacting with our host for today, and that's Mr. Chesley Hamilton. So we take you back to both the caller and Mr. Chesley Hamilton.
Yes, man, I'm back here.
Yeah, go ahead.
Yeah, I want to say thanks to him for coming on and having these discussions. Very well needed. What happened, we're not looking far down the road as much as we should. Like he's mentioned before the break, the people who are buying into the CBI program, in the near future, their offsprings will be able to run for political office in St. Kitts Nevis. And the bottom line here is that we need reforms. This electoral and constitutional reform is very well needed in the Federation. We haven't removed or added an I or a T. One law I know that they took up off the books was the boogering law. They didn't consult the people, and a lot of people in the community are against them taking that law up off of the books. It's the issues that I'm seeing in the Federation, the politicians of the day, they don't have the integrity, they're selling out the place, and they're not representing the people that's put them there. The people are definitely calling for constitutional reform. If the Constitution is faulty, that means we are operating a country under a faulty constitution. So therefore, the constitution must be reviewed. It must be changed. Otherwise, all aspect of community and government, all aspect of governance is faulty underneath that constitution. The constitution got to be revisited and changes got to come. And the people, I don't know why they're so timid. Why they're so timid to go in the street and demand changes. Because they think that the politicians are going to change things for them. They're not changing anything to benefit the people. So the people got to demand these changes. And one way to demand these changes is through peaceful protest. Persons are intimidated. they're scared to lose their jobs. The prime minister himself made a statement in parliament. They are the first administration to declare or pass a law that underselling the passports is criminal. He don't have to do that. Underselling the passport from get-go is illegal. And we have a lawyer in the house. If you commit an illegal act and you get caught by law enforcement, aren't you going to get charged?
Mm-hmm.
So and then the AG made a statement. He wants the salary of the parliamentarians to increase to stop them from being corrupted. All of those intangible morals that our parents instilled in us, it's in the heart. If a man gonna be corrupted, no amount. As a matter of fact, the more money people get nowadays, it seems like the more corrupted they get. And I'm going to take it back to the Brian clause, right? Before I get off, the Brian clause is going to come down to pledging allegiance and loyalty to the federation. If a politician's behavior, they put their hand on the Bible and they take an oath. But if they break their oath, that means that their loyalty and their allegiance gone through the door. So therefore, if their behavior is such that it seems like and appear like they're doing such things, like criminal activity and other stuff, how much loyalty and allegiance do they really have to the Federation of St. Kitts and Nevis? And if they break their oath and their behavior shows such, that means they don't have no more allegiance and loyalty to the Federation than anybody else. It's all in the heart. I don't care. We need the reform, and the people need to agitate for that. And lastly, before I get off, the Hamilton in the studio, I know you're a lawyer. We see a lot of stuff play out in America, in the court system. Why aren't we seeing? Things that's political. When the president go and he signs some of these what do you call those again, Quint?
Executive orders.
Yes, the executive orders. When he go and sign the executive orders, right, and those executive orders are not run through Congress, they are challenging court here. But I'm not seeing that happening in the Federation of St. Kitts Nevis. There is no lawyers on the ground who would take any cases up as such to either represent for the people or to challenge the government. And that's my contribution, man. I'm gonna leave it there, and I'll keep listening. Thanks a lot, and thanks to the guests for coming on. And if you can give your contact numbers out, man, you'll be appreciated. So people can maybe contact with you and get to have some discussions off the air. Thanks, man.
Okay. Chesley?
Well, I am grateful for him and his contribution. A young lawyer said to me recently, having studied in Jamaica, graduated top of his class, he said, we don't have an active bar here in St. Kitts. Some of these things that are happening, if we had an active bar association, some of these things would be challenged. But too often our bar association and the people who forms the executive of the bar, they are passive and they do not want to get involved in contentious or controversial issues. And I don't know why, because it's not like they depend on the government for their livelihood or anything like that. But I'm going to give you a first world example. In 1982-83, Canada adopted a new constitution under Prime Minister Trudeau, Pierre Trudeau, not Justin, Justin's dad. And in that new constitution, they patriated, they didn't say repatriate, they said they patriated the constitution from Britain because really and truly they brought it home so that they could amend it. the Canadian Constitution was really the BNA Act, the British North American Act, which was an act of the British Parliament, and therefore it could be amended by the British Parliament. They brought it to Canada and make it a Canadian document, and therefore Canada could amend it. It became the Canada Act. And, you know, one of the things within that constitution was a charter of fundamental rights and freedoms. That charter of fundamental rights and freedoms, in order to give it life and to give substantive meaning to the words on the page, the government offered to fund challenges on the certain sections, that if you were going to, take the government to task to give the fundamental right, let's say to vote, or the fundamental right or to equality or something like that, substantive meaning within the Canadian context, the government undertook to fund that challenge. They did it for a limited period of time. I think it's either 20 or 25 years, so that they would encourage the courts to pronounce and give substantive meaning to these areas of our constitution. That is one of the things that we have failed to do. We have a constitution. It's there. The paper is there, but we are afraid to say, listen to me. If somebody is going to take a fundamental question to the courts, we are going to, as a country, benefit from it. So we are going to fund that. We don't want to do that. We don't want to fund anything because Chesley, we don't like to be challenged.
Hold your thought. We have another caller. Hello, caller.
Wonderful.
Hello, caller.
Good morning.
Yeah,
good morning.
Yes, yeah, and your guest. It seems as if Lawyer Hamilton is totally against judge-only trials, but isn't it a more efficient way of delivering justice as compared to the jury system? It's less disruptive, for one thing. We don't have that many people who whose lives are going to be disrupted in trials. And secondly, and the people best qualified to deliver justice, the ones who are trained in like the laws and knows all the nuances. And I'm thinking, when I said judge-only trials, I'm thinking at least a judge, a defense lawyer, and a prosecutor. Leave it at that, okay? And within those three, there should be enough moderating opinion to dispense justice. And remember too, from time to time, the public gets outraged at jury trials themselves because, for one thing, they do carry their biases into the courtroom, as much as the selection process try to remove that. But the emotion is more likely to play a part there in jury trials as opposed to the scenario I spoke of in terms of a judge, prosecutor, and defense lawyer. So I would say I wouldn't go as far as to say it's a step backward. What would be good, though, is if the layman's input comes with the selection process of both the judge and the prosecutor. So the interest of the layman, I guess, are protected there. Okay, and let whoever the accused choose whoever defense lawyer he wishes, right? Or no defense lawyer at all if he wants as well. So I don't think it's as clear cut.
You're saying to me that jurors, they have biases, but judges don't have?
No, I'm not saying that.
Okay.
What I'm saying,
right.
The
but the system is designed.
Well.
Let me say this. The system is designed, okay, that where jury make errors, then you have the appeal and the appeal court. All right? and you also
Right.
have, you know, here, whether it is the Privy Council or the CCJ. So you have a process that there is another forum to review.
And that would exist. Even with
But
just
your statement about more efficient, what you call inefficiency? Please elaborate.
It would be quicker. It would be. It would.
Stick a
Yeah,
pin.
I'm
Stick a
saying-
pin. Stick a pin.
It would be less
Last
expensive,
year,
it would be less expensive.
last year, we had probably less than less, and I'm going to be generous, less than 10 cases done in the last fall, in the High Court, right? And I'm being very, very generous. Okay. We have less cases being done now, okay, than when you had just jury trials. This is the first time we have, and if you were listening from the outset, we have almost 100 cases not tried. Okay? So
Yes,
I am simply saying it has nothing to do with the jury trial. The juries are not responsible for no
there's
delay.
nothing to do with that?
Juries are not responsible for no delay.
But
Where
don't
does
you
the
agree,
jury,
though?
where does the fact that a jury is sitting and listening to a case and coming up with a decision result in delay? Where?
For one thing, there's the selection process, right? That in itself can take time, can take up time.
We
because all
select a
kinds of
jury
objections
we
can
select
arise.
a jury more often than that within a morning of a trial. That's it. You have 40 odd people and you go through the list and choose and choose 12. And thanks to a great decision by one Anthony Gonzalez when he sat as a judge, we now don't have the prosecutions standing by the whole array and just giving the defense three objections.
How many people normally sit on a jury?
Yeah, I like the question, you know. We now have 12 plus, in some cases, alternates. You may get
So
two
you're
or three
disrupting
alternates.
12. So you're disrupting 12 at least 12 persons' lives, when really and truly it could have been just 3 who, by the way, are doing what their job normally entails.
But you're talking about justice. What are you talking about interrupting?
Yeah, that's what I'm.
We're talking about interrupting when it comes to justice.
That's what
we're
I'm
not,
wondering.
Listen to me. We're not talking about civil matters, you know. Hold on there. Hold on, Mr. McMahon. We're not talking about civil matters where it's a matter of convenience. It's a matter of money. It's a matter of who is liable and who is not liable. We're talking about a person's life and liberty.
Yeah.
What the interruption you're talking about when it comes to justice? You want to go back to the Wild Wild West when the hangman judge come in and say he's guilty and he don't care? Or take him out to the square and hang him at noon?
But that's what I'm saying. You would think that that legal people with all their training in the law, right? And I would imagine they would have some sense of morality and duty and all of that. Okay?
But you see lawyers being charged every day. Every week you see a lawyer being charged for all manner of evil.
Yes, but
you
could say the same. But you could
Mr.
say
McMahon, you would trust me to decide me, Chesley O'Neill Hamilton, to decide whether you're guilty or not guilty and going to spend the rest of your life and a significant time behind bars? Me what?
Don't we do that? But don't we do that when we go before a judge anyway?
No.
And doesn't the jury? Doesn't the jury? Isn't the jury instructed, given instructions by the judge as well?
The judge is supreme and the law. Let me say it again. The judge is supreme and the law. The jury is supreme and the facts. And let me go further. Listen to this part. And this is going to give you the nub of the issue. The nub of the issue is this. If I have a trial, and where 12 jurors are sitting, and 3 of them don't agree with the 9. It's called a hung jury. Once ago, it means I get a retrial. Another 12 may sit to decide the case. You know what happened now? If there's a hung jury, it goes back to 1 man. 1 man. Okay? And you're going to tell me that that is justice? But give me the chance with 12 people any day.
Mr. McMahon.
Any day.
Mr. McMahon, there's a saying, justice must not only be done, but it must be seen to be done. Now, you can have, from your scenario, you can have some individual who are legally minded, legally of faith, and they make a decision. But the masses of the people don't feel that justice was done. The jury process, as prolonged as you may seem to think it is, gives you time to scrutinize, to go over evidence, prosecution, defense, cross-examine, blah, blah, blah. This is why Chesley is asking you, we're dealing with justice. You do not expedite.
I agree. I understand that, Pat. We're dealing with justice. And
yes.
I'm saying, and all I'm saying is, the justice depends on the laws as well. Okay? You may have bad laws. Okay? So you may have bad laws, but the fact is, there are laws. And if it's ruled by law, if it's the rule of law, then we have to be consistent. And we can't put in our emotions when we feel like. We have to go by the law. I would imagine, Chesley, that you took an oath basically to do that, right?
To what?
Not to twist the law as you see fit, but to apply the law.
I don't.
Is that correct?
No.
No?
And the word twist. My job is to advocate resolutely on behalf of whoever I'm representing. That is my job. I don't make decisions
based on the law, right?
But
you
I always tell you that the profession that I exist in, we have 50% failures. In order for me to be right, somebody's going to be wrong.
Okay.
50%.
Yeah. but because we assume that the law is there, it's there for everybody, and it's there to be interpreted.
Exactly.
Okay? And so people may have different interpretation, but in the final analysis, and that is what.
But you're not talking about just the law. You're talking about the facts, and therefore, if you tell me that the judge who is supreme on the law is advising himself of what is factually also correct, then I have a problem with that.
Yeah.
But he's the one isn't he the one most qualified to do that?
Who gave that one person the monopoly on what is factually right and wrong?
However the judge is chosen right now. Okay? And that is why I say it would be good if there was some kind of electoral.
Give me 12 people any day over one.
Right? You have to have confidence in
give me the community. Give me the community, the people. I have confidence in the people.
Look, the ultimate community thing is when you have mob rule, and we know how that just gone.
But majority rule. If the mob is saying factually, right? If the jury is simply saying, listen to me, this man was found with a donkey, right? And if he's found with a donkey, it means he stole it. And the judge said, listen to me, if you find that he took the donkey, he is guilty. If you find he didn't take the donkey, he's not guilty. And if the jury said, he could, listen to me, we are saying as a jury, he's found with the donkey, he could keep the donkey, and he's not guilty. If the jury says that, that is what they find as a matter of fact. And whatever the jury find as a matter of fact, it might not be what the judge find as a matter of law. That is why you have a separation of those two issues. So therefore, if you... No, let me finish the point. Let me finish the point. If you then have a problem, You then say, listen to me. I have an appeal on law. But the jury has already found the fact. You may have an appeal against what the judge finds as a matter of law. And that is how the process goes. But when one man is finding what is law and what is fact, it is far more, and this is the word I'm going to use, it is far more incestuous.
Yes.
Far more incestuous. And I don't like it.
Chesley, what I'm saying, Chesley, you're more likely to have a mistake in terms of an emotional response to a case from a jury than a judge. That's my opinion, right? And secondly,
and you
right?
are choosing you are choosing a one juror over 12 jurors. Because that is what you're doing. Because you're saying a one juror who is a judge is better than 12 jurors. That is what you're saying.
Look, Jesse, one of the things that upset the public a lot is when people get away on what you all call technicality.
There is no such thing. Right? And I'm going to stop you there. There is no such thing as a technicality. I am not a technician. I am a legal practitioner. I practice law. If I found something within the law which helps my client, I have used the law to benefit my client. That is not technicality. I hear people, he get off on a technicality. That is not a technicality. That is the law.
Wait, exactly. You see, and that's what I'm saying. You could use whatever you want.
And lawyers, the lawyers who are practicing don't write the law. Parliamentarians write the law. Nobody say, well, the parliamentarian wrote a bad law. If they write a bad law, then they go back and they amend it. But don't tell me I get off my client on a technicality. It is the law. And if the law is in favor of my client is found not guilty.
But Chesley, okay, we're dealing with let's deal with a practical case here.
Yes.
You have a reputation of being able to get off people, let's say, okay?
And I don't like the phrase get off. I don't like the phrase get off. I have a track record of success.
Okay, yeah, well, that's what I say. You can euphemize it all you want, right? But that's the reality, okay? And it upsets people because people feel, the same people who would be in a jury would feel that, well, you just get a smart lawyer and you're home free. And to me, and to the people, I think, that is not justice.
Really?
Okay, you may say it's using the law, right? But the law, as you know, can be filled with holes, right? And we've had endless history have shown repeated examples with bad laws.
Mr. McMahon,
okay?
You and I, not the judge, and many times not the jury, we were not there when whatever happened. We were not there. Okay? What happens in a courtroom where the prosecution and the state, with all of its resources, bring evidence to the court to prove a case? And many times they bring in DNA, they bring in forensic evidence, they bring in technology. They bring in all sort of things to bear on a case with all the resources of the state. Okay? And if they can't meet their burden, and if they can't meet the elements of a case, that's all my job is. I don't make the decision. But I am simply telling you, I will choose 12 arbiters any day over one. On serious matters. And listen to me, on serious matters. Because they're going to say, well, isn't it, they're going to say, isn't it, when you go before a magistrate, one person? Yeah. Those are summary issues. Those are of a lesser nature. And therefore, if you could go and get quick summary justice before a magistrate, you'll take that route. But on serious indictable matters.
I wouldn't look at it that way, because I would say all sin is sin. right? All injustice.
But I'm not God.
I don't care.
I am not God. You are not
I
God,
don't care what level
and therefore what you did is between you
who,
and your God. I am not here practicing who did it and who ain't do it. I don't practice that.
Who feels it knows it?
I wasn't there. I wasn't there. The state gives me a bundle of statements and evidence, and if they can meet they make out a case to answer in that bundle, that's my job. I am not there to know who did what and who didn't do that. I wasn't there.
I'm not arguing that, you know.
But that's what you're arguing if you want me to be God.
No. What I'm because look, I've spoken to somebody in the legal profession who's very high up, who was very high up, well known internationally as well, and I asked him point blank one time, is the court system in the OECS as transparent, as fair as they would lay it out to be? And he absolutely refused to answer that question, which itself gave me the answer.
No.
Okay?
A right to remain silent doesn't mean that I'm culpable. Even Jesus Christ before Pontius Pilate remained silent. So how does my silence give you your answer?
I know if it was a jury who was deciding the question and you didn't answer, I know how the jury would feel.
No, it is a right to remain silent. Okay? Even Jesus Christ before Pontius Pilate remained silent. Until when Pontius said, you say you're the king of the Jews. He said, no. They say I am the king of the Jews. That is how far that... So how could my silence, which is a right, tells you that I'm guilty?
If a defense lawyer asks an accused point blank, did you kill such and such? And the man say, I refuse to answer.
But sometimes
you think that ain't going to have an impact? You think that ain't going to have an impact on the jury?
The fact that I took a knife...
It would not have an impact on the judge.
The fact that I took a knife and stabbed you, right? It says, yes, I did the act. I killed you. I caused your death. But how did I cause your death? Was it in self-defense? How did I cause your death? Did you attack me and I then got the upper hand? How did I cause your death? It's not a matter of the fact that I take a knife and you died at the end of that knife means that I am guilty of murder or manslaughter or whatever it might be.
I know, I understand that.
The rules of the game.
But what I'm asking you, if you're before a jury and something like that happened, don't you think it would have an impact on the jury? It might not have an impact on a judge who knows the guy's rights and knows that he has the right to remain silent. But I'm asking you, don't you think it would have an impact on those 12 members you selected?
The judge's job is to tell the 12 members that you are to draw no adverse inference from his silence. It is his constitutional right. If the judge failed to do so, that is a fatal failure. But if the judge does that and explain it to the jury, that listen to me, you cannot draw no adverse inference from him remaining silent. That is his constitutional right. He can stay there and say nothing. He doesn't have to answer anything. It is the state that brought him here. The state brought him here. The burden is on them. The burden never shifts. It is for them to prove his guilt beyond a reasonable doubt. Those are things that the judge will say. But I have a problem now. The judge got to tell himself those things.
But caller,
the judge has to tell himself those things in a judge-only trial.
You honestly feel that silence would not have an impact on the jury, regardless of what the judge says.
But caller, that is what Chesley is saying. Even if it has an impact on the jury, when the judge, that is why it is set out the way it is set out, and that is why we prefer a jury case, because after the jury...
No. In this particular thing, the guy is more likely to get justice from a judge who understands his rights, rather than a jury who says, why you can't answer the question?
Because, again, as Chesley said, the jury deals with the facts. The judge deals with the law. So you see the difference?
When the judge has to deal with both, the judge has to tell himself has to tell himself, oh, I'm not to draw any adverse inference from his silence. The judge got to tell himself that. But
Because he knows the law. Because
he's making a
because he's
mockery
familiar with the law.
of criminal justice in my humble
because he
opinion.
knows the law. He knows the law.
Oh.
But the juror,
I know
the
it too.
juror, but the juror is not acquainted with the nuance. That's what I'm saying. A jury is more likely to make a decision.
Let me show you something. We have people on the bench. We have people on the bench who say, well, when you put the charge to him, what did he say? Well, why didn't he say anything? They're asking those kind of questions. You have to say to them, he has a right not to say nothing. It's his constitutional right. In South Africa, not remaining silent and adverse inference could be drawn from your silence. It's not every place that you're silent.
Exactly.
It's not every place. So I'm just showing you the law is different in different places.
It's not as outrageous as you think then. So that is not as outrageous as you think.
No, but you practice law, and therefore the jury is told by the judge what the rules of the road are, and that they're not to take an adverse inference from him remaining silent. It is his right, his constitutional right. But if the jury goes on to make an error, it's an error that can be corrected down the road, because that is the process.
With the judge-only trial, I assume that there's still the right of appeal somewhere else.
Yeah, there's a right of an appeal, but yes, you then deal with it with scholarly language and writing in terms of what your artistry and your penmanship and your learning, and you bring all these things to bear. You can do you cover it in those terms, and I cannot have confidence. Let me tell you this: I cannot have confidence in one man's bias. And I'm going to repeat it because that one man has, let me tell you something, they have cultural bias, they have geographical bias, they have pigmentation bias, they have racial bias, they have all kind of bias.
And those exist in juries as well.
Right, but what is the probability when you have 12? What is the probability when you have 12?
You just mean that you have 12 more people who are biased. That's all it means.
No. You have 12 more people, and the odds of you maybe even finding 3 that may agree with you is substantially more. And you must be honest with yourself. And that's all we ask. We ask for a fair trial, fairness.
I'm just saying.
Fairness.
I'm just saying, right, that it is not. I don't think it's as catastrophic as you made it out to be.
I had a judge in this country that told me one time. A judge told me, boy, if me and Ian Queely was in charge of this country, right, we would just clean up this thing with it. A judge is telling me that. So the judge was more prosecution than the prosecutor.
And that is the problem, caller.
That judge was more prosecution than the prosecutor.
Mr. McMahon, let me interject here. That is the problem. So you're saying, Mr. McMahon, that you don't have a problem with the judge being the one who presents the case, the one who scrutinizes the case, and the one who makes the decision, or he's what they say. He's judge, jury, and prosecutor. He's everything.
No. I said clearly that I don't mind having a judge, a defense lawyer, and a prosecutor.
And I'm going to give you this last bit, Mr.
Right?
Mr.
But Chesley, the crux of the matter is, do you have confidence in the judges that we have appointed here?
To do what?
To be fair.
To who?
I mean, to who? who is accused?
You hear the questions?
Who?
You hear the questions?
No. That's the question. Do you have confidence in the judge, in the justice system as a whole, and in the judge in particular? Because just being a judge, right, means that by whatever process, and the process I agree can be flawed, you have been put there as this wise man, wise guy, well, I'm not going to say wise guy, this wise man who knows the law, who is fair, who has some sense of morality, okay, and who has some sense of justice, right? That whatever he decides, because somebody have to decide, and it can't be. If you're going to say, well, I prefer 12, I would say I prefer a referendum on the from the whole country, and that's why I talked about efficiency, right? And the amount of disruption that is caused.
Mr. McMahon, Mr. McMahon, having trust in someone doesn't mean that they will be just.
Having trust in someone doesn't
I
mean
have
that
confidence in the judges that when it comes to the law.
Having trust in someone does not mean that they will be just.
Let me answer your question. I have
does
confidence
not mean
that
they
the
will
judges
give you justice.
with the judges
but Quinn, how I explain that? You have trust in someone, but you don't think that they would be just.
I said I don't. You're rephrasing my word. Let me repeat again. Having trust in someone does not mean that that individual will do you justice.
Okay. I have confidence that given the people on the bench with taking their oath seriously, right, to do justice to every individual without malice and etc., that they will do their best. But sometimes your best is just not good enough.
That's all we could ask for. That is all we can ask for.
Right, and I am not going to rest certain things in the trust. You listen to me. In the trust of an individual, if I have the opportunity to do it and put it in the trust of 12 ordinary citizens.
All right, just okay. I don't know. They are just like how I'm sure you wouldn't ask a doctor to defend you in a court of law, right? I would prefer to have a lawyer who then becomes a judge to be the judge of me in a court of law, rather than a doctor who I might have trust and confidence in.
Be careful, because I believe the best lawyer. I believe the best lawyer in the parliament is Denzel Douglas, eh? So be careful. So be careful.
Wait.
Be careful. Be careful. I believe the best lawyer in the parliament is Denzel Douglas. And I will tell you this, how I reached that? When you see what Denzel Douglas did with electoral reform, right? When he came with confirmation, when you see how he mirrored the committees instead of the commissions, when you see what Denzel Douglas did there, right? I could only tip my hat to him as a lawyer.
But that's politics. That's
politics to you. That's politics to you. That is lawyering. That is lawyering. That is lawyering to the highest degree.
An astute politician does not necessarily make you a lawyer. But truthfully, one question that I'd like to ask you, because I've been mulling over it a bit.
Yes.
How do you view the DPP as seem to be providing the oversight for the Integrity Commission? So it looks as if the Integrity Commission wouldn't act unless prodded by the DPP. I don't think the legislation had that in mind, but when people not doing the work, somebody got to provide the oversight. Somebody got to because you see, you see these photo ops or members of parliament and other people with their folders and declaring their assets and so on. You never get anything from the Integrity Commission certifying that such and such has filed and is under no investigation. His filings, we reviewed it and we clear him of anything. The impression you're getting is that, well, they might be questioning, they could question certain things, but the public is not going to hear about it.
Well,
the public
for me,
the public needs to know these things in order to make decisions on who's going to represent them. And if it's one of those departments that shouldn't just it's an entity that shouldn't just keep quiet and we assume they're doing their work.
And again, the Integrity Commission, right, cannot be an agent of the DPP. So therefore, if something is referred to the Integrity Commission, then the Integrity Commission must have the capacity to do its investigation, and if it has a certain finding, then turn it over to the DPP to prosecute. But it does not seem like that is where the bus is being driven. Okay? And if that is how the legislation is written, I have a serious fundamental problem with that. Because why am I declaring or not declaring my assets, right, to give to a DPP to prosecute me? Isn't that self-incrimination?
I would assume so. You're not going to give anybody rope to hang yourself.
Oh, okay,
right?
okay. So therefore, if I am dealing with an integrity commission and I have run afoul of my processes with the integrity commission, and they're giving me time or an opportunity to correct whatever and so on, and I have failed in some way, then they could say, listen to me, if you don't comply within this period of time, we're going to then recommend this. I could understand that kind of process and procedure. But you can't come tell me that the DPP is driving the bus in terms of who gets charged and who is brought before the court and so on out of the processes of the Integrity Commission.
Who get prodded to do what? And so what this sounds like is that it's not just Denzel Douglas, who is a great lawyer in Parliament, but a whole lot of them who basically put something in place which they know have loopholes. I mean, as a matter of fact, the Integrity Commission in Nevis actually complained that they don't have the jurisdiction and shift stuff over to the federal Federal Integrity Commission, right? When you have things like those, you got to wonder if there isn't collusion between members of Parliament to make sure that really and truly they're not really held accountable, you know. And as a citizen, I find that offensive. I hate when politicians come with these kind of smartness and pull wool over ordinary people's eyes.
That is the Westminster system where the executive and the legislature is one, and you know that the magistracy is also part of the executive. You know that? You know the magistracy is not part of the judiciary, it's part of the executive.
Oh, really?
You know, when a magistrate needs toilet paper, they got to go to the PS within the ministry. That? You know, when they need paper towel to wipe their hand,
we know that.
Paper, you know where they have to go? So the executive controls the magistracy.
Because a previous speaker was on record as saying, well, the branches are not really separate because our salaries, this is a former speaker, you know, our salaries are paid for by the executive. And so who pays the piper calls the tune, right? And what I'm saying, but that we have to accept.
So Mr. McMahon,
can we change these things?
Mr. McMahon, that latter part of the statement that you made, and you further said that the piper, who pays the piper, doesn't that bring into question all that was being discussed before?
Right, that the state is calling the tune in terms of what is going to be justice? That is the fairness that you're talking about, and that is the inherent bias that I am guarding against?
Yes.
Okay. Well,
that is the inherent bias I'm guarding against.
Do you feel that things would ever change, even if you point out these deficiencies? That things would ever change?
There's a political will. I mean, if when I came here, when we used to talk about marijuana, when we used to talk about 113 and all of these things, if I had come here and feel like nothing can change, boundaries, electoral reform, when I came here back then, I felt like nothing could be changed. Nothing could change. I do believe that there could be change.
But what has changed? We still under the same system. So long we talk
but in
about
the last election,
reform
a certain side put in place that they're going to move to a federal to a republican system, and so on. But maybe the public wasn't ready for that at this point in time. You look, I came here one time, and I said, right, when we're talking about the CCJ, and I said give the people an option, right, whether they want to go Privy Council or CCJ. And people laugh at me and say, well, how dare I? The CCJ is a final court, and how dare I say such a thing? I said to them, there is no political will.
Yeah,
I said to them, there is no political will. And listen to me. Listen to what I said. Why I was saying that. Why I was saying that is this. All justice is based in confidence. Grenada had all the seats with one parliament. With one party. Went to a referendum and couldn't get the public to decide to go to the CCJ. Same thing in Antigua. Gaston Brown had all the seats and couldn't get the majority necessary from the people to go to the CCJ. And I'm basically saying, if you had given the people the option, they would have, by choosing the CCJ, because it is more efficient, listen to that word, more efficient, it is more cheaper, it is more cultural, in tune and sensitive to issues. What would happen with the Privy Council is that it would be grandfathered. It would be made obsolete. And the reason for me saying it at the time was the Canadian experience. Canada had a Supreme Court. And in 1949, after the Canadian Supreme Court brought certain decisions into being, the Canadian population realized and the politicians realized, well, we are getting better justice from our Supreme Court than we are getting from the Privy Council. And therefore they made a move to decide, look, we have reached the point now where we have a body of work that we can rely on, and we are simply saying we don't need the colonial masters. My thing was, until you get a critical body of work coming out of the CCJ, the people are not going to have the confidence to feel like they can go towards it. That's it. Even with the political, overwhelming political support in Grenada,
right,
and in Antigua, you couldn't get it to go to this because all justice is based in confidence, and there was not the confidence coming from the people up to now.
And so that was a failure of leadership. Wouldn't you say?
I agree with you. Who is going to be the Abraham, as one judge said? Who is going to be the Abraham?
Let me interject. We're going to have to wrap it up. So caller, made your final statement, and then Mr.
No, I'd leave that to Chesley.
Okay.
To pitch one more time about his
well, I'm always grateful for you for being the devil's advocate. Somebody has to argue against sainthood.
Hey! I was not devil's advocate. I really believe
somebody has to argue against sainthood.
In efficiency, I really do believe it's more efficient, and in dispensing justice. I honestly believe that. So it wasn't. This wasn't a case. I know I do that sometimes, but this wasn't a case of devil's advocacy. Okay.
Okay.
I'm an advocate for God, not the devil. Okay.
Well, somebody in the Vatican has to argue against sainthood, and it seems like that's you, and that person is called the devil's advocate.
Yeah. I'm an advocate for good and God, I think.
All right.
All right then.
Okay, Chesley, your final roundup. We're 1
Quint,
minute over the
like I
clock.
said, when I come back, I want to bring to the people a little thing about the plea bargaining legislation.
Yes.
And some of the things that I see in it, and some of the things that I think goes with all of what is happening here in terms of how justice is being dispensed in this federation as we move forward, and let people be aware of what is happening, not only in Parliament, but on the ground, and, you know, in criminal justice on a whole in the federation.
Okay. So, Ms. Chesley Hamilton, thank you for taking the invite to come here. It has been a very, very interesting discussion, as we knew it would be with someone like you sitting in that chair. So thank you again for gracing the studios of winnfm 98.9, and we will be looking forward to hearing from you again quite soon. Take care.
You found the sound. 98.9. Win FM.
We now bring you the headline news. The headline news is brought to you by The Grange and Carib Brewery.
Maybe it's the way the brilliant gold liquid reflects our sunshine, or how the bright blue of its label mirrors the clear Caribbean skies overhead. Maybe it's the fresh, crisp taste of this beastly cold beer on a scorching hot day. Maybe it's even the way it brings us all together. But one thing is for sure, Carib is very much a part of who we are wherever we're from in the Caribbean. Carib. It's the way we play. Drink responsibly.
Did you know that the Grange Healthcare Facility is the first purpose-built, non-governmental healthcare organization on St. Kitts? It's situated at Otley's, 7 miles east of Basseterre in beautifully landscaped surroundings. The Grange has a team of highly trained professionals and provides care that's rated as being comparable with UK and North American standards. The Grange offers varied accommodations to suit your individual needs, and our all-inclusive packages make the cost of care per hour the most competitive on the island. Services include convalescent care for all ages, daycare facilities for older adults, rehabilitation services, and training and continuing education for healthcare providers. For more information, call 466-5525 or 465-8020. Fax 466-8221 or email thegrangehealth@gmail.com or visit our website at www.grangehealthcarefacility.com.
With the WinFM Midday News, I am Kevon Brown. Our top stories. CARICOM foreign ministers convened in Basseterre amid a shifting global landscape. SVG Finance Minister refutes rumors of ECCB governorship bid amid regional controversy. Adriana Young's family reject one-person investigation help. Prime Minister Dickon Mitchell welcomes Trinidad and Tobago's interest in hydrocarbon cooperation with Grenada. Internationally, India-Pakistan ceasefire. Trump says India and Pakistan have agreed to a ceasefire. Now the details. The 28th meeting of the Council of Foreign and Community Relations, COFCOR, commenced its opening ceremony on May 8, 2025 in Basseterre, St. Kitts, drawing foreign ministers and dignitaries from across the Caribbean community, CARICOM. The two-day gathering centered on addressing pressing regional issues and forging stronger diplomatic ties amid a rapidly evolving international environment. The Right Honourable Dr. Denzel Douglas, Minister of Foreign Affairs et al. For St. Kitts and Nevis and newly appointed Chair of CARICOM's Council for Foreign and Community Relations, in remarks at the ceremony underscored the challenges facing the region and broader global community.
Secretary General and colleague ministers, I am confident that our discussions today and tomorrow can only be enhanced by the backdrop of the natural beauty of our twin island federation that we are so very pleased to share with you. Yet, this environment of calm and beauty that surrounds us belies a shifting and the troubled geopolitical and economic landscape, where the rules-based international order is now being eroded by the attempts of some to undermine multilateralism, and of course the rule of law.
Highlighting the erosion of once sacrosanct partnerships and inalienable principles, Dr. Douglas expressed the urgent need for a realignment of priorities for many of our countries, especially as the lingering effects of the COVID-19 pandemic and various armed conflicts continue to permeate the global economy.
These circumstances, they constitute an inflection point for this, our Caribbean region. They demand a unity of vision and mission to weather the tide and to identify and implement innovative approaches to achieving regional and national development goals.
The minister emphasized the significance of broadening CARICOM's partnerships beyond traditional allies.
In this vein, the continued bolstering of our efforts to deepen relations with non-traditional partners, even while we